tax protester.
Thank you. Let's see if we can get switched on here. All right, we on? Surprisingly, in the Bible, there is a fellow by the name of Gideon who was the first recorded tax protester in history. You may have heard of him. His name was Gideon. He fomented a rebellion against the Midianites in which, by the time the war was over, about 90 days later, he'd killed 135,000 of them and overthrown the government. The subject matter that was so interesting was that prior to his selection as the new leader or the new judge over Israel, he was hiding his grain in the wilderness. And an angel came to him and he said, now let's overthrow the government. And Gideon was a little concerned about this and he said, shh, you don't know who might be listening. Does that sound like the United States of America today? You see, if we want to talk about taxes, we have to be very careful about where we talk about and what we talk about for fear that, even though I'm paying my taxes, it could foment an audit. And boy, that's the last thing we want to hear, isn't it? Nobody wants an audit. Why is it that we're so fearful and timid of this thing called the income tax? When I asked you yesterday how many of you liked it, no one raised their hands. Now, if we don't like something, could it be that if we ignore it and pretend that it doesn't exist, that it will go away? Do you think that the Federal Reserve System and the IRS, the income tax, and government regulation and control will disappear if we put it out of our minds? I first came into contact with this concept about 1978. It began innocuously with an OSHA inspector who came into my factory and he wanted to do an inspection. I asked him if he had a search warrant and he said he didn't need one, so I threw him out physically, and things haven't been the same since. Now, I thought America, the land of the free, the home of the brave, required a search warrant to search. But you see, I hadn't read Colonnade Catering or Biswell versus U.S. You see, there are some exceptions to the rule. And I'll have to concede that I was in error when I threw the OSHA inspector out. But the ensuing litigation required that I do some legal research from which I came to a better understanding of the law and how the law works. Now, in 1978, I employed about 30 people year-round in a manufacturing business in Boise, Idaho. I produced approximately $1 million a year and paid about $200,000 a year in taxes to 28 agencies of government, from the city of Boise to the federal government in Washington, D.C. Now today, in 1990, I'm happy to report that I employ no one, produce nothing, pay no taxes, and I want to teach all of you people how to do the same thing. Because that is public policy. Government does not want us to produce. They want a monopoly for themselves. General Electric wants the monopoly on aircraft engines along with Pratt & Whitney, and they don't want you to invent some revolutionary new type propulsion system which would upset their monopoly. The fellow in Mississippi, Joe Newman, who has invented the new machine and applied for a patent, do you think the public utilities companies like PG&E and California Edison, or excuse me, it's New York Edison, want you to have some type of energy machine or electrically produced alternative to the power company? You see, the monopoly system is designed in such a way to exclude individuals from the marketplace while solidifying big business and big industry in that very field. The income tax, which came along in 1913, was the primary vehicle by which monopoly could be established. Let me show you how it worked. In 1909, a fellow named Paul Warburg came to the United States and he said, what you people need here is a central bank like all the nations of Europe. That fell right into line with what our forefathers told Samuel, who was the last judge in Israel about 1100 BC, when they came to him and said, what we need in this country is a king like all the nations around us. And of course, the concept of a central bank with a regulated monetary system appealed to the masses of people, because along with this came promises. That is, we'll tax the corporations, and when they pay the tax, you won't have to. And so there was a little element of greed. A little lust and greed was thrown out upon the waters, and people said, well, now that's a pretty good idea. Well, when the income tax was enacted with the Federal Reserve Act, I want you to notice that income tax and paper money came together in the same act. Because there's an old common law statute that says you shall not have an unjust weight or balance in your bag. It's against the law to deal in paper. So when the Federal Reserve came in to offer us paper, there had to be a methodology by which they could tax the paper out of circulation. Otherwise, you have a runaway inflation, which occurred in Germany in 1923. Notice that when the tax was first enacted, it only affected corporations, and the corporations paid approximately 1%. That is, you didn't pay any tax on incomes of $5,000 or less. And from $5,000 to $100,000, it was only 1%. And from $100,000 up, it gradually progressed upward, so that the average person making $5 a day in the Ford factory in 1913, which was $800 a year, wasn't even affected. By today's standards, you'd have to have a tax exemption of $240,000 in order to come around to the same standards that were applied to your great-grandfather in 1913. Now, the Social Security account number came into play in 1935. Between 1913 and 35, there was no tax on you and I. The wage earner working at the Todd shipyards had no fear of having his income taxed. In fact, between 1935, when the tax was enacted upon individuals under the Social Security regime, until 1943, you didn't pay a tax. The tax was first applied to individuals under the Victory Tax Act of 1943, and then was repealed in 1945 pursuant to the constitutional mandate that a direct tax can only be applied for 2 years during time of war. Well, the first man that I ever heard of that picked up on the fraud was A.J. Porth, who in 1944 was a business rep for a labor union. And he noticed that when the Victory Tax Act was repealed, the income tax took its place. And his first question was, where did this power come from? And the answer is, it came from the Social Security Act, which had been enacted 9 years previously and was sold by Arthur Altmeyer Jr., the first commissioner of Social Security, as being an insurance policy. Well, it isn't an insurance policy. It's called by the Supreme Court a welfare scheme. It is called social insurance, but it has no property rights. And it's the first premium of a tontine wagering policy, of which it is a double indemnity policy, and the tax would more rightly be called a premium. You know, when you pay Mutual of Omaha, you don't call it a tax, do you? But for some reason, when you pay your Social Security premium, it's called a tax. Well, the income tax in reality isn't a tax. It's the other half of the premium. Let's take a look at what the courts have determined over the years. The Social Security account number is a grant of extra common law limited liability franchise, upon which benefits and costs, which are called an excise tax, may be levied. It is a license required by the state from individuals before they can be hired by corporations. Corporations are creatures of the state. These state-created corporate franchise employment is extra common law and can therefore, in addition, be indirectly excise taxed as an additional franchise. Now what we learned from that is working for Mutual of Omaha, General Electric, or Bendix is a privilege. You have no common law right to work for a corporation or for a state government. It's a franchise, it's a privilege, and an excise tax is called a privilege tax. Secondly, the Social Security account number is a congressional grant of grace. It is a grant of franchise of right in the nature of that described in the class of cases represented by New Colonial versus Halvering, cited at 292 U.S. 435. And introduces us now to corporate law, which in ancient times was called the Roman law merchants, which has its origins clear back to the Tower of Babel, but more recently, about 945 BC on the island of Rhodes, and progressed through the Middle East and was last codified by the Hanseatic League of Germany. And it was called the Hanseatic League of Merchants, of which the East India Tea Company was one of the members. Today, in your state, you call it the Uniform Commercial Code. Underlying this corporate law is a more important body of law, which is called the Law of Corporations, or the Uniform Commercial Code. Corporations are juristic state-created persons. Under corporate law, the creator, the state, of these corporations may demand anything that it prefers from its creature within constitutional bounds, and it may regulate it in any manner whatsoever. Shockingly, the state may destroy or create a person, then regulate it by taxation, or can even destroy it by use of taxation. See Enoch versus Williams and VZ Bank versus Fenno. Both cited at Enoch versus Williams is cited at 370 U.S. 1, and VZ Bank is cited at 75 U.S. 533. So it's a franchise privilege that the state of Colorado grants to General Electric to operate its franchise within the borders of Colorado. Now, when you go to work for a corporation, you create a three-party limited general partnership, just like you do with a marriage license. The corporation offers you employment. You offer the corporation labor. The state offers a franchise. The three of you enter into a business arrangement with the intention of making profit and gain. And the income tax in the last analysis is simply a portion cut from the income and appropriated by the state as its share of the joint venture. Wages were not taxable between 1913 and 1935. The tax on wages did not appear until 1942 with the Victory Tax Act. Of course, it was very convenient to place this tax right in the middle of World War II so that anyone who opposed it would be called a Nazi or a Japanese sympathizer. In 1913, the income tax laws, the 16th Amendment, later incorporated as 26 U.S.C., was ratified and passed. The income tax laws at that time clearly applied only to corporations, which are state-created creatures. Additionally, wages from common law endeavors were not taxable. One does not derive income by rendering services and charging for them. See Edwards versus Keith. Rendering services and then being taxed on the proceeds from the services, such as a service station or a mechanic, a carpenter, a plumber, an electrician, were not then, nor are they now taxed, because the tax does not attach to your labor. It appears to attach to your labor, but your labor cannot be taxed because it's called an inalienable right, and it's protected by the Constitution and by laws. and, surprisingly enough, by the Taft-Hartley Labor Act of 1947. So the tax is not being applied to your labor. It's being applied to something else. Now, however, it seems that what we might call wages, which were exempt under prior law from taxation, are in fact now taxable. Well, if wage earners weren't being taxed between 1913 and 1942, something must have occurred during that period of time which would have given government the power to levy such a tax. Remember, the Victory Tax Act was not the income tax. The Victory Tax Act was passed and repealed pursuant to the constitutional provision from 1942 to 45, which prohibits government from levying such a tax for longer than 2 years, and there must be a war in progress to levy the tax. But you'll notice, some of you old-timers maybe remember this, the tax never ceased, even though the Tax Act was repealed in 1944. This seems at best to be an absurdity, and absurdities are not tolerated by law. An absurdity in law is called a constitutional vague and ambiguity, or an ambiguity or an absurdity in law is intolerable, or just plain unlawful. Could it be that the government is acting unlawfully and taking part of your wages and calling it an income tax? Absent a clear statutory reversal of the older cases. The answer, however, lies in the fact that excise taxes can be levied upon an exercise of a state-created privilege or a franchise, and not just upon corporations. The Social Security franchise of limited liability, it works, and the license to work for corporations may be taxed, and it may be subject to other statutory regulations. When you applied for your Social Security number, you said in effect, I'm unable to manage my own affairs, and I need a guardian. So you applied to the Department of Health, Education, and Welfare for a guardian to manage your financial affairs. And the government said, we'll manage your affairs, we'll take care of you and give you a security blanket from the cradle to the grave. We'll give you employment if you're unemployed. We'll give you welfare and security. All we want in return is all of your labor for all of your life. Or didn't you read those 732 pages of the 1935 Social Security Act before you signed the application? Yes, ladies and gentlemen, the entire text of the contract is in writing. It's always been available. And any judge will look at you and say, why didn't you read the contract then, if you're unhappy with the results now? And you might say, well, I didn't know anything about the Social Security Act of 1935. Nobody presented the contract to me. And that's true. That's because it's called an adhesion contract. Oh, you didn't hear of adhesion contracts in public school? By the way, who operates those public schools, ladies and gentlemen? Isn't it the government? And who operates Social Security, ladies and gentlemen? Isn't it the government? Would your government want you to know the answer to the riddle if you knew that you were worth $435,000 over the course of your life? Can you understand why government doesn't want you to understand the Social Security Act? Now, the IRS Form 1040 comes into play right along this line also, and it is in the nature of an installment note, yearly payable upon continued exercise of the franchise and its derivative of the law merchant. And among other things, this is why the IRS manual in the Legal Reference Guide at page 58, section 11 states, quote, in any case not provided for in this Act, 26 U.S.C., the law merchant shall govern. All states have adopted this in their uniform business and commercial codes. And you'll see this in the California Civil Code in 3439.11, the UCC 1-103 of Arkansas Uniform Commercial Code 85-1-103, Washington Revised Code 62A 1-103. Every state in the Union has such a provision. The government uses the power of attorney that was granted with the signing of the Social Security contract when they seek a redress of grievance. This is revealed in 26 U.S.C. 3101A. You might want to write that in your notes. 26 U.S.C. 3101A. It's the connecting link with Title 42, the section on the 1935 Social Security Act, Title II and Title 11. In other words, law is written line upon line, precept upon precept, here a little and there a little. It's the methodology whereby we keep you perpetually deceived because, first of all, you've never been trained in law, and secondly, those that are trained in law would have to be trained in legal research to ferret out the connecting links to tie the jurisdiction of Title 26 and the income tax to Title 42 with Social Security. The average mind simply cannot cope with such a system. Even trained legal minds have a hard time coping with such a system. 3101A of the Federal Insurance Contributions Act, called FICA, where it says, quote, old age, survivors, and disability insurance, in addition to other taxes. What other taxes do you think they're referring to? It's called withholding. There is hereby imposed on the income of every individual a tax equal to the following percentages of the wages as defined in Section 3121A, received by him with respect to employment, as defined in Section 3121B. What the bottom line to that is this. Without a Social Security account, you can't pay an income tax because you're not a taxpayer. The Social Security Act is the contract whereby you gave your power of attorney to the Secretary of Health, Education, and Welfare. It was under that power of attorney that you gave him the authority to tax you under the Income Tax Act of 26 U.S.C. Now, the connecting link has to do with money. It doesn't have to do with the Social Security Act of and by itself or the Income Tax Act, because there was an income tax in the United States during the Civil War. In fact, the first income tax passed in the United States was passed by New York State in 1778, a little known fact of our historical past. Let me tell you a riddle, and then let me see if you, like Judge Wapner, can ferret out the answer. When I was a little boy, my daddy used to send me to the grocery store. It was Connick's Corner Grocery. And he'd write a note on a 3x5 card or a scrap of paper, and it would say something like, Dear Harry, please give little Georgie a loaf of bread and a quart of milk. And he would sign it, Daddy Gordon, and he'd put a little P.S. down there, I'll pay you when I see you. He'd give me the note. Now, I'm 5 years old, and I would take the note with me. I'd take it down to Harry and put it on the counter. Harry would take the note and read it, and he'd go get the bread and milk, put it in a paper bag, lead me over to the door, give me a little handful of grapes to appease me, and then he'd give me instructions, and he'd say, now, little Georgie, you go right straight home with this bread and milk, which now raises a legal question. When little Georgie walks out of the store, who owns the bread and milk? Is it little Georgie who's in possession? And all of us know that possession is 9 points of the law. Is it Harry Connick who hasn't been paid yet? So until he's paid, transfer of ownership of the property can't be consummated. Or is it Daddy Gordon under the terms of some invisible contract? Well, as you can see, there has to be some form of judicial methodology whereby we can adjudicate this question of law. Judge Wapner would know instantly who owns the bread and milk. Let me see a show of hands. How many of you think little Georgie owns the bread and milk? Possession is 9 points of the law. Very wise of you. You know the law. But the question of Harry does come into mind. How many of you think Harry, who hasn't been paid, still owns the bread and milk? Ah, now you see, there's a division here. We're approaching an absurdity here. And then, of course, there's Daddy, who wrote a contract. And a question arises, does the contract supersede the common law and Harry's title to the property? How many of you think Daddy Gordon? As I look out over the audience, let the record show that the division is approximately 1/3, 1/3, and 1/3, which just shows that this audience does not know who owns the bread and milk. Ah, but the law does. You see, my Daddy Gordon owns the bread and milk as an operation of law because little George is a ward of his daddy. And at age 5, he has no capacity to own anything. So he's called an agent. He's the agent for his daddy. Now, Harry was given a tender offer. The note said, "Dear Harry, please give little Georgie a quart of milk and a loaf of bread." And Harry said, "Okay, you've tendered me an offer, and I'm going to give little Georgie the bread and milk, upon the promise that someday you're going to pay me the 35 cents. So he entered a contract, and the moment Harry gave the bread and milk away, it was gone. You've heard the story of Indian givers, you know, the kid that gives you something and then says, "I want it back." Well, Harry is entitled to something, but he is never entitled to the bread and milk. And if he were to sue upon the contract, he could never collect the bread and milk. He can only collect something in lieu of the bread and milk. Now let me give you an answer from the court, and let's see whether or not we can put that riddle into perspective as it relates to the income tax. In Stanek versus White, the court said there is a clear distinction between a debt discharged and a debt paid. Now if I asked you, did you pay your tuition for this seminar this week? How many of you paid? Let me see your hand. Thank you. How many of you discharged? Let me see your hands. One fellow. Stand up. The only man in here who discharged his obligation this week. Everybody else paid. Now let's see what you paid. When a debt is discharged, the debt still exists, even though it's divested of its character as a legal obligation during the operation of the discharge. Something of the original vitality of the debt continues to exist, which may be transferred, even though the transferee takes it subject to its disability incident to the discharge. Oh, that sounds kind of legal term, doesn't it? That's a little difficult to follow. I'll translate that for you in a moment. The fact that it carries something which may be a consideration for a new promise to pay, so as to make an otherwise worthless promise a legal obligation, makes it the subject of transfer by assignment. Stanek versus White. What that says in English is this. There's a distinction between a debt discharged and a debt paid. When a debt is discharged, instead of paid, the debt continues to exist because it has not been extinguished. That's what bankruptcy is. When you go to bankruptcy, you're discharged in bankruptcy, but you didn't pay anybody anything, and the debt continues to exist. A discharge relieves the payor of the debt. That's the fellow who offers the discharge. It relieves the payor of the debt of the obligation to pay right now. That is, I don't have to pay you now, I'll pay you later. but the debt continues to exist until it is paid. The discharge transfers the debt to the party who accepts the discharge. The discharge is compensation paid in lieu of the payment. The party who accepts a discharge accepts or agrees to accept it with all of its disabilities. Now let me ask you this. When you walked in the door to pay your fee this week, how many of you used Federal Reserve notes? Anybody? Oh yes, there were a few. How many used checks, credit cards, or other forms of negotiable instruments? Well, let's take a look at one of these notes, these green pieces of paper, and it says at the top of it, Federal Reserve Note. Now let me ask this question. Who owns this piece of paper? The Federal Reserve Bank or George Gordon? It tells you very plainly right on the face of it that this is not a George Gordon note. And I'll admit to that. This isn't my note. This Federal Reserve note was issued by the Federal Reserve, and it's Daddy's note. Now let's ask you this question. All of you people in here are wearing shoes, are you not? How many people in here own their shoes? Let me see a raised hand. How many of you people in here do not own your shoes and you're wearing somebody else's? Oh yes, there are a few out there who know whose shoes they're wearing. Now let's go back to the answer to the riddle. When little George walked into the store, he tendered an offer to Harry. When you went into Kmart, you tendered an offer with a piece of paper to Kmart and said, "Can I have the shoes?" And they said, "Well, yes, we'll sell you these shoes." Notice they didn't trade you the shoes, they sold the shoes. And you discharged the obligation with a Federal Reserve note. When the store gave you the shoes, you became the equitable interest holder, the holder in due course of the Federal Reserve Bank's shoes, and you're wearing their shoes. Now, of course, a lot of people say to me, "So what? Big deal." Well, it's a very important fact of law because how did you pay for your automobile or your house? Didn't you pay for it the same way? Now the question comes up, who owns your car? Who owns your house? Who owns your shirt? Who owns your shoes? Because if you paid for them with a Federal Reserve note, you didn't pay, you discharged. Now I'm a cat of a different stripe. Now I've got a pair of shoes on, I own my shoes. I own my home and I own my car because I paid for them with gold. And I have a bill of sale on everything I buy and it says paid at law with gold. Because I don't want to rent my house, my car, or my shoes from the Federal Reserve Bank. Because at some point in time, they might say to me, "I want my shoes," which would leave me barefoot. They might say, "I want my car," which would leave me afoot, or my house, which would leave me in the rain. And I don't want to rent my property from somebody else because I'm exercising a privilege in commercial estate instead of paying my debts at law and owning my own property. Now that's the important distinction. In addition to that, I don't pay an income tax, which saves me $200,000 a year, which remember I used to pay when I operated the Atlantis Manufacturing Company. The right to labor and its protection from unlawful interference is a constitutional as well as a common law right, and every man has a natural right to the fruits of his own industry. Remember I said, they're not taxing your labor, boys and girls. They're taxing something else. Now let's find out what they're taxing. Labor is deemed to be property. That's a very important legal distinction because labor is not a commodity. It's not a commercial enterprise. Labor is property, especially within the meaning of the constitutional guarantees. And thus the right to acquire property includes the right to acquire property by labor. The right to earn wages is just as much property and within the protection of the Due Process Clause of the 14th Amendment to the Federal Constitution as are earned wages. Now let's take a look at this note again and let's see how this applies to you. Let's suppose that you take a job at General Electric. General Electric agrees to pay you $100 a week. At the end of the week, did you ever notice that they don't give you a gold coin? They don't give you any electric motors. They give you a check. So in place of the gold, which is property, they give you what's called a chosen action. We'll use this $100 bill as the example because it's the equivalent of a chosen action in interstate commerce. So you worked for the week and you gave away, like Harry Connick, you gave your labor away. It's gone now, Harry. And in order to compensate you for your loss, they give you this $100 bill, which belongs to the Federal Reserve Bank. It's somebody else's note, somebody else's piece of property. Now you go down and buy your shoes with somebody else's piece of property who has your power of attorney, just like my daddy had my power of attorney when I went down to get the bread and the milk. And when I walked out of the store, I didn't own it. Did you notice that they take about 25 to 75% of everything you create and produce? That's the tax. That's the commission that the Federal Reserve Bank takes because you went to them to get the exchange medium to settle your debts. It's a three-party contract between you, the state, and the store. When I make a contract, it's a quid pro quo contract, which means substance for substance. When you come to my farm and buy one of my cows, I charge 3 ounces of gold. And before you load the cow, you hand me the property called gold. Most people don't do business that way. They write a check and take the cow. The check is the negotiable instrument in interstate commerce. The tax is upon the check. The tax is not upon the cow. If you could transact your business without using dollars, you wouldn't owe an income tax. Now, income taxes are a recognized method of distributing the burdens of government. They've been favored because requiring contributions from those who realize current pecuniary benefits under the protection of the government, and because the tax may be readily proportioned to their ability to pay. Taxes of this character were imposed by several of the states at or shortly after the adoption of the federal Constitution. See the New York Laws of 1778, page 17 in the report of Oliver Wolcott, Jr., Secretary of the Treasury to the Fourth Continental Congress of the Second Section. The report was made in 1796. So an income tax is not a tax upon your labor or upon your property. Your labor is property, and your property cannot be assessed or taxed. But when you exchange your labor for a dollar, the dollar can be taxed because the dollar is a profit or gain, and the tax derives from the Commerce Clause at Article 1, Section 8 of the Federal Constitution, wherein Congress was granted the power to regulate all commerce. Dollars are used as the medium of exchange for settling debts between nations, between corporations, and if you use dollars, then you're being treated or you're acting in a corporate capacity and you're being taxed just like General Electric. Now, this argument of the income tax resolves itself upon a mere question of definitions, and it has no legitimate bearing upon any question raised under the federal Constitution. Let me read that again, because many of you may be involved in tax litigation in which you have been told, or you may believe, that the income tax is unconstitutional, or that the Income Tax Act it's the 16th Amendment, wasn't properly ratified. This argument upon analysis resolves itself into a mere question of definitions. It has no legitimate bearing upon any question raised under the federal Constitution. If you walked into court and you applied a constitutional defense to your income tax, the judge would throw you out of court instantly if you were a licensed attorney. He'll revoke your bar card right on the courtroom floor. Remember, it's a matter of definition. It's not a matter of constitutional construction. The income tax, ladies and gentlemen, is not constitutional, nor is it unconstitutional. It is extra-constitutional. It is contractual, and the contract is with Social Security. And the Supreme Court of Idaho laid the issue to rest in 1933 in Diefendorf versus Gallet, when they explained it this way. Diefendorf is cited at 51 Idaho 619, and on page 633 the court says, quote, "Income is necessarily the product of the joint efforts of the state and the recipient of the income, the state furnishing the protection necessary to enable the recipient to produce, receive, and enjoy it, and a tax thereon in the last analysis is simply a portion cut from the income and appropriated by the state as its share thereof." So you have entered a three-party limited general partnership. It's called a joint venture. The state produces the corner upon which you can produce your monopoly. You're in a monopoly as a doctor, a dentist, a lawyer, and you pay a fee to the state for the privilege of operating in this limited capacity, this monopoly. Income then from this monopoly, which is charged in dollars, called income, profit, and gain, is necessarily the product of the joint efforts of the state and the recipient of the income. It takes two to tango. And if you want to create a monopoly, then the state has to come in with the police power and protect your monopoly on that corner. That's why people want licenses. Because if you're a licensed doctor, no one else can practice medicine without a license. And so then you come back and you say, but I want to buy this cancer curing product. But wait a minute. The American Medical Association has already licensed, copyrighted the word cancer. It's a copyrighted trade name of the American Medical Association. And only one of their licensed practitioners can use it. It's like Coca-Cola. Now maybe your Coca-Cola tastes better. Maybe it's cheaper. Maybe it's more healthful. But without the Coca-Cola bottling company's license, it's a contract violation. You can't make Coke. Now you can make Gordon Cola or Johnson Cola, but you can't make Coca-Cola. Can you understand that? You can treat the botch of Egypt, but not cancer. Cancer is a copyrighted trademark. It's a monopoly. And it's against the law for you to interfere in somebody else's business monopoly because they pay an income tax on the joint venture with the government. And it produces $165 billion a year for cancer treatment in the United States. Now that's what the income tax is all about. Government does not need your money to function. They have all the credit in the world. They need to tax your wealth so that you cannot compete with General Electric. Now, what we're really dealing with here is religion. Perhaps you've heard it said that there is a clear distinction between religion and the state. I think that was a misstatement. I don't believe it for a moment. I think the state is organized religion, and I want to show you now on the board what happens in the state when you are dealing with the George Orwell symptom or the concept that he used called doublespeak and doublethink. If I told you that this is a blackboard and this is a podium, and I said, look on the podium and see the words I've written, you'd say, this man's a lunatic. Obviously, he's writing on the blackboard and speaking from the podium. What we do is we change the definitions of words over a period of time so that wages today are income. But when you go to an old law dictionary like Bouvier or Black's First or Second, you find that wages are property, and property isn't assessed or taxable. So where it came in was with the enabling clause of Social Security, in which the Social Security Act says in the enabling clause, for the purposes of this act, the following definitions shall apply. Wages, salaries, tips, commissions, and gifts shall be construed as income. You go to the public schools and they teach you to deal in wages, salaries, tips, commissions, and gifts. And then, of course, the government comes along and says, out of your own mouth, you've admitted that this is a tip. Out of your own mouth, you've admitted that this is a gift. And aren't these wages, salaries, tips, commissions, and gifts always paid in dollars? If they were paid in gold, silver, wheat, corn, beans, honey, and oil, they'd be property and non-taxable. Now let me show you about our judicial system that Eustace Mullins brought up this morning. He said it was a little corrupt. Yeah, I'll go along with that. There's a little corruption there. But more importantly than that, it's a religious system that comes from Exodus 18 and Exodus 21. It is the judicial system that was established by Moses. Not because Moses was corrupt do we say our judicial system today is corrupt, but because the system today is a perversion of the Levitical priesthood, which is now called the civil service. Now, I noticed when I came into Colorado that you have what's known as policemen. I saw them out there on the highway. And those policemen out on the highway are looking for crime. I know. I watched some crime being committed, and the policeman races right up and catches the criminal and then takes him to jail. And I noticed also that the jail is located in the courthouse. The courthouse has what's called a courtroom, and this is where they take the defendant. They take him before a judge in the courtroom, in the courthouse, after they've taken him from jail. He comes up before the bench. It's an important piece of furniture because to protect the bench is a bar, which is a rail. And if you want to see how important this bar and this bench is to the sacrament that goes on in the courthouse, just lean on the bench and see what the judge says. It's absolute sacrilege. I tested it once. Once. And this judge wants you to have a lawyer so that you can cross the bar to approach the bench. You don't do that when you go into an insurance office to buy an insurance policy. Then this lawyer wants to enter a plea for you. Then the judge finds you guilty of crime. This makes you a criminal. And he levies a fine. And did you ever notice the fine is always accompanied by court costs? Isn't that strange? Every court in America levies fines with court costs. Did you know that every court in Poland levies fines with court costs? And they do the same thing in the People's Republic and Japan and Argentina. Now, if you don't like the decision you got out of this judge, you can take it to the Supreme Court. You can appeal. And this is called the civil service. Now, in ancient times, when Moses ordered the system in Exodus 18 and in the book of Leviticus, you'll find that this policeman was called the high priest's servant. You'll remember Peter cut off the high priest's servant's ear when they were in the garden. That's called assault today. Secondly, this thing called crime is known as sin in the Bible. When you break a law, it's called sin. You'll see the definition of that in 1 John 3:4. Then they put you in ward. Remember, Peter and the apostles were constantly being put in the dungeon. They called that, we're going to put you in ward. We're going to hold you until they can take you to the temple. And that's where the dungeon is. It's in the temple. And where's your courthouse here in this county? Is it here in Denver? Is that the temple here in the county? Is that where your jail's located? Then they take you into the courtroom, which in ancient times is called the holy place, before the high priest. How do your judges dress out here? Do they all dress in dresses? Yeah, they do that back where I'm from too. Now that's a little strange, don't you think? It's the only place on the planet where a man dresses in a dress to go to work. But that's an important symbol. You see, he's wearing the holy linen ephod, which was white or red. But this guy's got the color right because he's working for Satan. He's got the black linen ephod, and he's going in there to enforce the Roman civil law, the Uniform Commercial Code, at the altar, which is called the bench. And he sits on the altar, and you approach the altar through the veil. You had to pass the veil to get into the holy place. This is, of course, the fellow who takes you in there, the lawyer, is called the intercessor. For those of you that are Catholics, you understand how Mary is the intercessor, and you can't go pro se to the throne of grace boldly. You've got to go with Mary. To do what? To offer a prayer. And in a civil action to this day, it's called a prayer for relief. And who are you praying to? Aren't you praying to the high priest, who finds you guilty of sin and levies upon you a sinner, a sin offering, which in ancient times was a ram of the first year. You see, under the common law, we deal in property. Under the civil law, we deal in choses and action. So if you went to a Levitical priest, the Levitical priest would say, okay, I find you guilty of the crime that you've been charged with, and I'm going to fine you one ram of the first year, which is worth about $100 in today's money. But he would also lay upon you a heave offering called 2 turtle doves. So he would require that you bring him 2 chickens or 2 turkeys, and he took those home and fed his family with them. In Idaho, this is called the Judge's Retirement Fund, except that you pay it in dollars, and he's paid a retirement check, and he goes down to Safeway and buys his turkeys and his chickens. But it doesn't make any difference whether you give him the chicken or the turkey, or he buys it from Safeway. It's still the same system, except that we've changed the names, you see. That way it's not religious. Now, if I call this guy over here a judge, oh, well, that's very secular, isn't it? If I call him a high priest, well, that's kind of religious, ain't it? Now, after the heave offering, if you don't like this, you could appeal this to the Holy of Holies. You appealed this to Aaron the high priest, and you did this once a year in the Holy of Holies. This was called the Levitical priesthood. Today we call it the civil service. That income tax that you're paying is the tithe that you pay to your God, the state. That's what the bottom line is. Well, I thank you so much for your time. It's break time for dinner. If you'd like to learn more about this, my table is over here on the left side in the back. You can get my calendar for 1990, and you can get our little blue cards, our registration cards, and tell us what you're interested in, and we'll be more than happy to talk to you back there. And of course, we have our workshop on Monday, and we have a special workshop on Tuesday. There's 2 sign-up sheets back there in the back. Sign up on those 2, and we'll tell you a little bit more about this judicial system and how it applies to you. Thank you so much.